Hi, I'm Lauren Burns with SJF Law Group in Plantation, Florida. Today we're talking about how a Florida personal representative decides whether to sell, hold, or rent a home, and how it all fits into the Florida Probate Timeline. Picture this. The house is sitting, the power bill lands, the HOA wants proof of insurance, and the family asks, are we keeping it, renting it, or selling? There is a clock, rules, and money on the line. Let's keep it simple and walk through a clear path. Step 1. Know your role and the probate timeline. In Florida, we use the term personal representative, not executor. In formal probate, the courts often issue letters of administration a few weeks after the case is filed, but timing depends on the county and the case. You need letters of administration before you sign a listing, lease, or deed. Then a 3-month creditor period starts after notice to creditors goes out. Most estates wrap up in about 6 to 12 months. Sales often happen during the course of the case, not at the very end. In summary administration, there is no personal representative, and the courts don't issue letters of administration. The court instead enters an order to transfer assets to beneficiaries. Real estate sales wait for that order, then heirs sign the deed to transfer the property. Step 2. Identify the type of property. Homestead, the decedent's Florida primary home. Homestead often passes to heirs outside probate, but we still ask the court to enter an order determining homestead to protect it from creditors and make sure title is clear. A personal representative does not control protected homestead. Heirs do. A sale needs the heirs' signatures. Non-homestead, rentals, second homes, vacant land. A will with a power of sale gives direct authority to the personal representative to sell these assets. If the will is silent as to the power of sale, plan on needing to ask the court for an order approving the sale. Joint ownership or trust. If title was joint with rights of survivorship, the surviving co-owner owns the property outside of probate. If a trust owns it, the trustee handles the sale through trust administration, not probate. Step 3. Build a quick house budget. Mortgage and lines of credit, property taxes, and homestead exemption status for the year of death. Insurance, including wind and flood, HOA or condo dues and special assessments, utilities, and basic upkeep. Now, the decision tree: hold, rent, or sell. Hold works when a spouse or child plans to live in the home. For homestead, heirs control. For non-homestead real estate, the personal representative maintains and keeps property safe for the estate. Keep up with water and electricity, mortgage payments, association dues, and other time-sensitive expenses. Use an estate account to pay bills. Rent. A personal representative has authority to lease estate property under Florida law. All rent goes into the estate account. For homestead that passed to heirs, heirs decide on a lease and collect rent. Screen tenants use Broward and city rental rules. Condos often need tenant approval. Plan time for that process. Know the tax angle. At death, the property basis resets to fair market value on the date of death. Florida has no state income tax, but federal rules apply. Sell. Makes sense when the estate needs cash for debts or distributions. Beneficiaries want proceeds instead of money, or holding costs are high. Steps for title and escrow. 1. Confirm who has authority. Personal representative with letters of administration and either a power of sale in the will or a court order authorizing the sale, or for homestead, the heirs after an order determining homestead has been issued by the court. 2. Provide the title company a certified death certificate, letters, the will, and any court orders. If a summary administration, provide the order of summary administration and the homestead order. 3. Expect an HOA condo estoppel letter, payoff statements, and lien searches. 4. If the creditor period is still open, title often holds proceeds in escrow until the 3 months run and known claims are resolved. This protects buyers and the estate. 5. Use a Florida probate-savvy realtor and closing agent. Label the seller correctly on the contract, estate of free by personal representative, or the heirs if homestead. Taxes at sale. Basis is the date of death value. A sale near that value often shows little or no capital gain. If the estate or heirs sell later at a higher price, gain applies. Obtain an appraisal close to the date of death to document basis in the property. Common roadblocks and fixes. Homestead confusion. If protected homestead exists, the personal representative does not sign a loan. Get the homestead order, then have heirs sign the deed. No power of sale in the will. Seek an order authorizing sale before you list or while listed. Build time for a hearing if required. Condo approval. Submit the application early. Some buildings require interviews or holdbacks for upcoming assessments. Vacant house risks. Install smart locks, keep lights on timers, and service AC. Quick Florida Probate Timeline recap for real estate. Open probate and secure letters. Send notice to creditors. 3-month window starts. Maintain, rent, or list during that window. If a sale closes before the window ends, plan on escrowed proceeds. After the window and claims are handled, release escrow and finish distributions. In summary administration, get the court order first, then sell or deed to heirs. One last thought, keep records. Log every dollar in and out. Use an estate account. Share updates with beneficiaries. Clear notes lower stress and speed approvals. We're here to make this simple and steady. If you found this video helpful, please give it a thumbs up. Also, don't forget to subscribe to our channel so you can stay notified whenever we upload a new video. Thank you for watching today.